I remember I made you rush. And then I let the tap run for the defense. I'm not sure I should limit you again. And let you proceed until you finish. But just an indication, how long will you take?
You know, because of the abundance of kindness that you have, we have agreed that our learned colleague, Mr. Witty, is going to respond. And he had indicated earlier 7 minutes. I think we got additional 3 minutes of the submissions, including that have been made by a president. So we can anticipate 10 minutes to respond.
Okay. Thank you, Your Honor. I will undertake to do under 10 so that I don't keep my seniors here, including my president, who today seems to have forgotten the prosecution are also his members. Okay. Having said so, Your Honor, we have listened carefully to submissions from our learned colleagues for the defense, and we understand where they come from. However, seated where I was sitting, 98. Sorry, Your Honor. I am reminded that I should go slower than my usual speech. Your Honor, I was indicating to court that with the benefit of my mathematics prowess, 98% of the submissions before you today has been on alleged, and the word alleged is chosen deliberately, alleged violation of fundamental rights and freedoms. Because that is a jurisdictional issue, my submissions will start from that point. And our invitation to this court is that when you retire, to determine the only question before you today, which is whether the respondents should be released on bail pending hearing and determination of the charges before you. That this court should be minded that whenever a court does not have jurisdiction, it must not make any more step. And that rule applies also to independent issues before you. And one such issue is whether or not this honorable court can entertain, hear, and or determine questions of alleged violation of rights and fundamental freedoms. Your Honor, the jurisdiction of the magistracy, the court to which Your Honor presides, is defined and prescribed by Section 8 of the Magistrates Court Act 2015. Section 8 is your jurisdiction to the extent that you can hear and determine alleged violations of human rights. And that section says that you can only hear questions of alleged violations of Articles 25A and B
testimony.
Articles 25A and B. And that means the alleged violation of the right to legal representation, the alleged violation of the right to food, the alleged violation of the right to discrimination, right against discrimination, which was raised by my learned senior Mr. Omari under Article 27. Sorry, Your Honor. I mentioned the right to food, right to freedom against discrimination under Article 27. All those fall out of your jurisdiction. And you cannot hear. In fact, in normal expectation, it would have been that the court would have stopped submissions on those points. You cannot hear and you cannot make determination around them. This is not to say that the ODPP, whose jurisdiction I'm going to mention second, denies or accepts that there were such violations. But we are saying that the forum for that determination, the forum for such a hearing is outside your mandate, and they cannot be the basis of your consideration. For the avoidance of doubt, the jurisdiction to hear and determine questions of alleged violation of rights and fundamental freedoms belongs to the High Court of Kenya under Article 165(3) of the Constitution of Kenya. (165(3) of the Constitution of Kenya, 2010. Related thereto is the jurisdiction to hear and determine any question as to whether any law or